work for ALTECH Environmental Consulting Limited, and we are fortunate to have Rick here from BLG. And today's presentation is New Brownfield Development Rules in Ontario. Are you ready? Today's presentation is going to be 45 minutes. We're going to end right at 1 o'clock. If there's questions and answers that go beyond that, we can stay online for those people that want to. We also will have the slides available for anyone who wants it, and it's going to be put together as a podcast that we're going to post on our website. And I understand Rick's group is going to post on their website as well. So let's get started, and I'm going to hand over the presentation over to Rick.
So good afternoon, everyone, and thanks for joining us. What's otherwise, I'm sure, a busy day for everyone. My name is Rick Coburn, and I'm a partner with the Environmental Law Group at BLG. And as John has indicated, today we'll be discussing a package of proposed regulatory changes related to brownfields with a primary focus on proposed new regulations relating to excess soil management. But at the end of the piece, we will also have a brief discussion of some changes in the RSC regulation. This package that we're going to discuss this afternoon has been announced on the ERO. The reference number is 013-5000 for anyone who wants to look at it. And it was announced in conjunction with the enactment of Bill 108, which is otherwise known as the More Homes, More Choice Act. However, a number of the initiatives contained in the regulation predate, and the connection with the legislation itself is, in fact, not direct in some cases. However, the regulations and the Act share the goal of promoting redevelopment. One caveat before we get into the agenda, these are still proposed regulations that we're discussing. The public comment period ended on June 17, and while we have every indication that the province intends to move ahead with these initiatives, there is always the possibility that the province, after they've taken into account the comments and other considerations, will either revise some of the content of the regulations or indeed make revisions to the proposed timing. So content and timing could change. In terms of an agenda, then, we're going to start off with a discussion of the proposed on-site and excess soil management regulations. We will then move much more briefly to the proposed amendments to the record of site condition regulations, and we will discuss a number of discrete topics under that heading. And then finally, we will be looking at, and my co-presenter John will be taking over the mic for this discussion of taking advantages of regulatory changes. So very briefly, what is the issue that the proposed regulations are intended to address? First of all, enormous uncertainty around the reuse of excavated soils on site and their disposal off-site. The treating of excess or excavated soils as waste potentially triggers enormous disposal costs and unnecessary transportation costs, so bad for the environment and also costly. Estimated 25 million cubic meters of excess soil generated in Ontario per year, according to government statistics, so you get a sense of the magnitude of the issue and the problem. And lastly, wherever there's uncertainty in the law, there's also potentially some incentive, we could say, towards practices that skirt around the edges and in some cases veer into the area of illegal dumping and other non-compliant practices. So what are we looking at in terms of new regulations, new instruments? As I mentioned before, there's an ERO posting which contains copies of all of the proposed instruments. We have, first of all, a new regulation proposed entitled On-Site and Excess Soil Management Regulations. And with that, if you go to the bottom of the list, is a guidance document entitled Rules for On-Site and Excess Soil Management, also referred to as the Soil Rules. And those rules, which are a substantial document, will be incorporated by reference into the regulation. They include not only standards and practices with respect to the risk assessment of excess soils, but also specific rules for each and every requirement that the regulation imposes. And then going back up the list to numbers 2 and 3, we have corresponding amendments to the General Waste Management Reg 347 and corresponding amendments to the Record of Site Condition Regulation Reg 15304. And we'll come to those in due course. So, core provisions governing the relocation and reuse of excess soil, these are found in sections 3 to 5 of the proposed regulation in its current form. And it begins by stating that excess soil is designated as a waste except if all of the following conditions are satisfied. And I've listed a number of the conditions. This is not an exhaustive list. There are others in the regulation. The main point I want to make first off is that the way that the regulation is framed, it works by way of exemption. So in other words, we're not taking away the entire existing system with respect to waste management and soils. What we are doing is creating carve-outs or exemptions if you follow certain rules and conduct certain practices in a certain way. So the consequences of that obviously are that if you fail to follow the rules, then you find yourself back under the pre-existing system, which the implications being that the material could be treated as waste, could be subject to ECA requirements, et cetera, et cetera. So the main conditions that need to be satisfied in terms of relocating excess soil are that the excess soil is being transported directly to a reuse site from one of the following: a project area, a soil bank storage site, a temporary soil storage site, or a soil processing site, and each of those locations is defined in the regulation. Secondly, the operator of the reuse site has consented in writing to the deposit of the excess soil. Thirdly, that the soil is dry and remains dry until it is finally placed. Fourthly, that the quality and quantity of the soil meets conditions prescribed in the regulations and the rules. And as I mentioned earlier, the soil rules in and of themselves are a voluminous document with many requirements. And fifthly, an identified beneficial purpose. A beneficial purpose is not strictly defined in the regulation. However, examples of beneficial purposes or beneficial uses are prescribed, and they include backfilling, final grading, achieving grade for certain purposes, etc. Key administrative requirements. So these requirements relate to what I would say are the two key players under the regulation, the project leader and the QP. So in order to implement and rely on the regulations, project leader must be designated who is responsible for managing process and compliance. That project leader in turn must ensure that a QP prepares any necessary or prescribed documentation in accordance with the rules and the regulation before soil leaves the area. The project leader is also responsible to establish and implement a tracking system in accordance with the rules, and we'll come back to that in a moment. And finally, the project leader is to ensure that a notice with prescribed information is filed in the registry respecting the project area and each reuse site. So types of documentation that are prescribed before relocation: an assessment of past uses of the project area itself, and then based on that assessment of use, the requirement for a sampling and analysis plan in most cases, and a soil characterization report. An excess soil destination assessment report with respect to the reuse site and prescribed declarations. So not unlike the record of site condition regulatory regime that we have today, the new regulations basically impose the responsibilities arising out of the regulation on the individual actors, the project leader, and the QP in most cases. What is a tracking system? A tracking system is described or defined in terms of what it is to include. So the language in the regulation currently states that it shall include procedures that will enable the generation and retention of information and will be able to produce records on request for a period of 2 years following transportation of excess soil to verify the following, and then it lists various bits of information that must be included as part of an adequate tracking system. What standards are prescribed? The soil rules set out the applicable standards for reuse of excess soils at a reuse site. As a general comment, it appears that Table 1 site condition standards can be applied in all cases. However, beyond that, there are a number of tables that apply, and in a similar way to the application of tables when applying for an RSC. So in other words, you have the same categories that are based on land use, for example, potable, non-potable water resources, et cetera, except that these tables are designed to be specifically for excess soil. In addition, the rules provide for the option of applying what is referred to by its acronym as BRAT. BRAT stands for Beneficial Reuse Assessment Tool. This allows a QP to generate site-specific excess soil standards for a potential reuse site, and it's using an Excel-based spreadsheet model similar to the MGRA type of model that exists today for risk assessments. There is a BRAT user guide which has been developed for the use by QPs, and a draft of that guide is also available from the ministry. So phasing in, the regulation in its current form is designed to come into effect in 3 phases. These are broadly described in the slide before you on the screen, and it's been broken down into sections in the regulation. So the basic concept is that the excess soil provisions relating to more flexible reuse rules would come into force and effect as of January 1st of next year, 2020, or the day when the regulation is filed. It would be the later or the latter of those two. A year later, then, aspects of the excess soil regulation related to sound soil management planning would come into force, and the sections that refers to are contained in the draft regulation. And finally, restrictions on landfilling of specified excess soil would come into effect as of January 1st, 2023, which would allow time to ensure alternate reuse approaches are available as needed. So I mentioned earlier that there are corresponding amendments in other regulations which are designed to fit in with the new regulation when it's brought into force. Examples of these are Regulation 347, the General Waste Management Reg, which will provide that excess soil is not considered part of the definition of inert fill if reused in accordance with the regulations. This too would come into force on January 1st of 2020. And there is a corresponding amendment also in OREG 15304, the Record of Site Condition regulation, which will state that soils may be brought to a record of site condition property if a QP has determined the excess soil meets the applicable soil quality standards that apply to the RSC property in accordance with the rules. So attempting to integrate the two regimes. This too would come into force on January 1st of 2020 at the same time as the bulk of the on-site soil management reg. So that presentation brings us to the end of our overview of the excess soil regulation. We'll now turn our attention to other aspects of the package that include proposed amendments to OREG 153 that relate to records of site condition. These are discrete changes to the regulation that respond to discrete problems that have been identified over the years by practitioners and brought to the Ministry's attention. And in each of these cases, the Ministry has responded with a proposed amendment to the regulation. So the first has to do with the treatment of mixed-use buildings. Under the current regime, it's a requirement that the most sensitive land use in a mixed-use situation be the governing factor in terms of the criteria to be applied. So that requirement is being changed in certain cases so that the requirement actually, it's the removal of the requirement for an RSC itself for a change in use in the case of mixed uses. So, for example, low-rise commercial to mixed-use residential with commercial on the main floor would no longer be considered a change in use requiring an RSC. Temporary roads in a construction area to residential would not trigger a requirement. Indoor places of worship to residential would no longer trigger the requirement. And similarly, industrial or commercial to indoor agricultural in or on the same building or property. The second area that has been touched by the amendments is the requirement for full delineation. This is a perennial problem in many cases where full delineation is either difficult or impossible to achieve. There's a partial relief that's being worked into the regulation that basically will state that full delineation is no longer required in support of risk assessment. The QP may instead conduct a non-standard delineation of a property that is already the subject of an approved risk assessment. The third category is the treatment of the sodium absorption ratio or electronic conductivity criteria. This relates, as most people on the line will know, to the application of de-icing compounds, road salt, etc. Currently, the regulation would only provide an exemption with respect to de-icing agents that are applied by a municipality. The intent of this regulatory amendment is to broaden that exemption so that it applies regardless who the applicant may be, provided that it can be established that the purpose was to apply the substance to surfaces for safety of vehicular pedestrian traffic under conditions of snow or ice both. Finally, a small grab bag of other standard exemptions. Site condition standards are deemed to be met if a QP is determined that there has been a discharge of drinking water within the meaning of the Safe Water Drinking Act. Where the concentration of a contaminant does not exceed the naturally occurring range of concentrations, there is likewise the ability to disregard that exceedance. So before I turn the mic over to John, I'm going to add one additional comment that didn't appear on the slides, and that's that the province has recently released the proposed new Provincial Policy Statement 2019 which is, most of you will know, is the overarching policy document governing land use approval in the province of Ontario. That document now contains a new policy which supports the application of excess soil reuse locally in the planning approval process. So again, an attempt to sort of integrate these regulatory initiatives with other areas of legal approval. So, John, can I turn the mic over to you?
Thanks, Rick, for that thorough examination of some of those regulatory changes. I'm going to talk for a few minutes on what I see as potential advantages for developers with respect to the regulations and taking advantage of them with respect to either cost savings or streamlining development. So I have a list here that I'm going to just go through in a little bit more detail. So the first one is with respect to greening development. And if you're not familiar with that term, it's a development that considers both environmental and social impacts, including environmental responsiveness, resource efficiency, and community sensitivity. And these regulations parallel the greening development concept. And if you approach the cleanup of a site with the view of being a more greener development, or if you want to be part of the Green Building Council, platinum, gold, silver, bronze building, there may be opportunities, added opportunities because of the reuse of excess soil and more points towards being either platinum, gold, silver, or green building. Secondly is using Phase 1 and Phase 2 environmental site assessments, and I have here beyond the basics. So the key to examination of a site using environmental site assessment is determine, first off, if there's a potential for contamination existing, and if there is, confirming it, and then delineating it. And if you look at the Canadian Standards Association guidance document or Reg 15304 with respect to Phase 1 and Phase 2, those are the base requirements for Phase 1 and Phase 2. Certainly been technology advancements with respect to field instrumentation and other practices. And for example, here at ALTECH, a standard Phase 1 environmental site assessment, we include a MAG survey, a magnetic survey, that will detect underground metallic objects. For example, and one of the key concerns when you're doing a Phase 1 environmental site assessment is there any underground storage tanks? And if you look statistically over the last couple decades about the major concerns for environmental Phase 1 and then subsequently Phase 2 is underground storage tanks, and then spills or discharges or leaks from those underground storage tanks that cause contamination. So if in the Phase 1 you can have added information, i.e. a magnetic survey that gives an indication of underground storage tank existing or not, because there'll always be a question about, there was one, did we remove it? We don't have records of one removing, or there doesn't appear to be records of one, but we know it's an older building, and at one point it was heated by fuel oil, and those sorts of questions are more thoroughly answered if you do a magnetic survey as part of your Phase 1 as an add-on, and you could argue it's a Phase 1.5. I don't want to get into too much semantics and start debating environmental consultants about that, but it certainly is a valuable tool to consider. And similarly with respect to Phase 2 environmental site assessments, there's been huge advances in field measurement technology where you can get very quick answers. And having worked with developers, that's one thing they always like, is very fast answers. They want the report the same day or the next day, and aren't always appreciative of the requirement for lab analysis, and are not always willing to pay the double fees for 1 to 2 day turnaround on the contaminants from soil and groundwater analysis. So if you can do field instrumentation at the site, you get the results immediately. They can be used as a surrogate if it's for regulatory purposes, and in some cases can replace the requirement for lab analysis, depending on what the purposes of that measurement is for. Thirdly, I have here the power of soil tracking technology. So depending on who you are, you may be a big fan of soil tracking technology or not. I would say if you wanted to do things above board, if you're a developer, you would be a big fan of soil tracking technology. If you look at Quebec, and if you know anything about what's happening in Quebec, and I've written a few articles about what's happening in Quebec and illegal soil dumping, Quebec government got fed up. One of the requirements is soil tracking, and it has come to the advantage of the good players because it evens the playing field, that you're going to make sure that your competition is disposing of the soil properly and following the same rules as you. And so it's definitely had success, and it has other success in that it could potentially lower some of your costs, and that leads into the fourth point I have is environmental insurance. So we did have a lecture, I think it was back in February, had Carl Spensieri here from Berkeley talking about different types of insurance products for developing properties. And if you do have soil tracking technology, it adds a level of confidence that the soil is going to the right place and potentially could lower your premiums because knowledge is power, and it certainly adds more information to the insurance company when they're insuring you. The fifth point is third-party verification. With soil tracking technology and the openness of it, you can provide that information to any third party that may be of interest. For example, your lenders. If you have a financial institution lending on the property, they want to have some confidence of where the soil is going. They don't want you being charged and convicted for illegal soil dumping. You can provide that information to them, and it opens up gives you the ability to give assurances that the soil is going in the right place versus the olden days where you paid someone money to get rid of the soil and you just hoped that it went to the right place, and if it didn't go to the right place, well, it was their fault. You paid them to put it in the right place. And as we can see, you may not be charged or convicted by the Ministry of Environment, but in the court of public opinion, it may look very bad on you, and in some cases worse than actual conviction by the Ministry of Environment. Lots of examples where there's issues like that. You look at Volkswagen. Yes, they got charged and convicted, $1 billion fine, US EPA alone, but their share price dropped, I think, $22 billion because of what was happening with that particular company and the illegal smog emission testing. My sixth point is the utilization of new field measurement technology. This has always been around, and one of the things that I see with respect to remediation of contaminated sites is you want to, yes, remove the contaminated soil and make sure it goes in the right place, but also the excess soil that's not contaminated, it costs less to reuse that, so you want that to be going someplace else. And if you utilize new field measurement technology, you can differentiate more accurately and more precisely what exactly is contaminated soil, where you're going to be paying between $55 and $75 per ton, depending on how well you are negotiating and where exactly that's going to, either a landfill or soil treatment site, or less than $10 a ton if it's excess soil. So you want to be paying the less than $10 a ton, in some cases as low as $2 a ton for excess soil, as opposed to that excess soil being treated as or managed as contaminated soil. So that is something to think about with respect to management and the utilization of technology to determine or delineate or accurately delineate what's contaminated, what's not contaminated, and what should be going to landfill and or treatment facility, and what should be going to for excess soil management. And then my seventh and last point deals with the advantage of soil repositories. One of the challenges of the points about utilization of excess soil and contaminated soil is usually developer wants a hole just dug quickly as possible. They don't want any management on site. There may be restrictions on area, etc., and timing issues. So with respect to a soil repository, that gives you the ability to move the soil to the soil repository and then subsequently doing the analysis on the repository and figuring out what's contaminated soil and needs further treatment, and that can be moved away from what soil is not contaminated. Also, with respect to soil repositories, starting, as Rick mentioned, in 2023, it's going to be more and more difficult, if not possible, depending on how the regulation is written, to get rid of soil, excess soil, at a landfill, which if you're not following where your soil is going, a good portion of it potentially could be going there. So there will be more soil repositories, and there will be more soil treatment facilities that will manage contaminated soil and be a location for excess soil. So it is useful to keep on track of what contractors and what companies are doing with respect to addressing soil repositories and with respect to opening up new facilities that aren't landfills but are either soil treatment facilities or soil repositories, or consultants and or contractors, and that's one of the things we've looked at as ALTECH, is taking advantage of this beneficial reuse assessment tool, or BRAT as the acronym goes, because the BRAT is a very powerful tool if used correctly, because then you can utilize excess soil at different sites, or utilize excess soil at another site that you own or at your own site. And it's yet to be taken advantage of as a useful tool, and I seriously recommend that you look at that closely. If you have any questions about it, want to discuss it further, I'd certainly be open to discussing it and what advantages it can potentially have. So those are my, I think, 7 points that I think where you potentially as a developer could take advantage of the regulations to either save money or to help with respect to marketing of the facility, or give you ease of mind or lower premiums, etc. Of the regulations. So not all regs or more regs are always bad. Certainly this one is one that, in my mind, and I think Rick is agreeing with me, that helps level the playing field and helps prevent the illegal dumping of excess soil and promotes the proper management of excess soil. So that concludes the formal part of our presentation. I'm a little bit proud that we finished early. We're not pushing it. If you have any questions, you can type them in and we can answer them now. We can answer them offline. As you can see from this slide, this is the contact information for Rick. Certainly open for either telephone conversation or email if you have an email question. And likewise, if you have any questions of ALTECH, I direct you to Chad Stewart, who's the manager, site investigation or remediation. He has a bigger brain than me, more knowledgeable on these issues. So I thank you for your attention and attendance at this. Like I said, if you want the slides, you could email Felicia, who's the organizer, and she'll send you the slides. And if you want to hear this again, or you want to have your colleagues hear it, we're going to post these for sure at ALTECH as a podcast, and I believe Rick, depending on the quality, is going to post it at BLG. You can look it up through there or contact Rick to find it on the BLG. Rick, do you have any other closing points?
I'd just like to thank everyone for taking time
Okay, great. So don't have any questions on the chat line, so we're going to conclude it. So great. Have a great summer day and a great long weekend.